Hello everyone, I'm Siddhant. As we are continuing the module D of the legal, and we are going to complete today because the whatever chapters are left, these chapters are very small, and it would hardly take, if you read even from the books, it will hardly take 5 minutes for one chapter each. And so I am completing the module D with this in two of my videos today, so that you could easily revise from the things. I am only completing the important points and the things, and what you need is to practice from the question bank or from any internet website where you being provided the module D questions for the practice. It could also serve the same purpose. So starting with the chapter, before the starting, I would like to convey one message that these notes whatever I have made, I have put it this notes into the Facebook group, the Banking Inside Out, the Facebook group. You can join there and you can download these notes, and because these notes are very easy for the revision things, because once you heard the videos, you learned the concept, you could easily remember that whatever I told you, and when you start reading the notes, then you could easily revise the things. And there are lots of things that is not in the notes, but I tell or I discuss it in the videos. So both are equally important as far as the examinations are concerned, and notes are for the revision. The best thing, or even the bestest, or if you want to say that bestest, then the practicing from the question bank is the best among all for the revision. So starting that, the contract of agency. This contract of agency concepts comes from the Contract Act of 1872, and this agency system is the birth of the contract. What do you mean by agency system? The agency system, like the LIC, Life Insurance Corporation, they appoint agents, and when they appoint agents, they do this contract, that is contract of agency, with the agents, so that because they are acting on behalf of the LIC, so the whole responsibility is with the LIC, because they are representing LIC, and if they represent wrong things about LIC, then it would be a very bad reputation among the customers. So they do the contract of agency with the agents, so that the rules can be complied of, and if the rules are not complied of, they could be taken under punishment or under charge according to the contract they did. So that's the concept of the contract of agency. Now this contract of agency has a principal, agent, and the parties. Who is the principal? In the example I gave, that is the example of LIC. The LIC itself is the principal, and the agents are the one who is appointed by the LIC to act on behalf of the LIC to sell the insurance to the customers, and parties are the customers. Now the agent acting on behalf of the principal to the third party, I already explained. Express or implied. Okay, what's the difference between the express and implied? So whenever there is a contract, two things comes into picture. There is a possibility that they will not write everything into the contract, and if they do not write into the contract, there are some things which are natural or universal, which should be implied, that is automatically applied. For example, if it is written that insurance are for the accidental cover, so accidental covers everything. It should not be explicitly write everything like accident from the fire, accident from the car, accident from the from in home itself. So accident means accident. It is implied that it could be happen through any means. That's the difference between express and implied. Express means it is written or orally accepted things, and implied, that is necessary or the important situations, which is by default applied to all the contracts, that is the implied. Now the next chapter, that is the contract of sale, and this contract of sale has some important terms like the delivery. What do you mean by delivery? Voluntary transfer of the possession of the goods from one person to another is called the delivery. It's simple. And hence, if a person takes possession of goods by unfair means, then there is no delivery of the goods. Okay, let's say one person is transferring to the other person, A to B, but C comes and by threat they took all the goods. So this is not a delivery because it's done through an unfair means, so it will not called a delivery. Now the law on sales, the duty of the buyers and the sellers and the concurrency of the payment and the delivery both together reference to. Okay, in this contract of sale there is one concept, important concept, that concept of unpaid seller. Who is called the unpaid seller? The one who is paid partly, or the one who is not paid at all, or the one who is paid the check or the draft and it has not been converted into the amount, or it has not been cleared through the banking process. So that is called the unpaid seller. And whenever the concept of the unpaid seller comes, there are some rights associated with the unpaid sellers, like resale of the goods first, the lien over the goods second, and lien over the goods even if the supplied the goods to the buyer and the buyer has not paid the amount. Even in that case, there is a right associated with the unpaid seller that he could lien the goods and he could claim that goods to return. And stopping goods in the transit, let's say it's already in the bus or truck to transport from one place to another, but unpaid seller comes to know that its check got bounced. So in the midst, in between the transfer, he could stop the transition and withhold the delivery of the goods. And if the goods are ready to deliver, and he can stop that goods if he is not paid according to the contract or according to the payment as promised by the buyers. So this is important. Okay, the contract of sale is the contract not by the Contract Act. It's a separate contract for the sale that is under Sale of Goods Act of the 1913. This is important, and section defines this between the 31 and the 40. The section 31 to 40 is important, not for the examination point of view, but section 31 to 40 describes the contract of sale. And if we take the law into concern of the sales, there is a duty, some duties for the buyer, there are some duties of the sellers which should be complied according to the contract of sale, and the concurrency of the payment and delivery both together. This is one of the law of the sales. Now in the contract of sale, there is one concept comes, that is condition and the warranties. So what do you mean by condition? Okay, for repudiation of contract. Okay, whenever there is a contract between the two person, that is, let's say the buyers and the seller, there are some conditions are put in the contract which describes that on what conditions the contract becomes null and void or the contract becomes cancelled. That is called the conditions. Let's say the contracts, in the contract itself it will be written that if the goods will not be delivered on 20th till 20th, then the contract stands cancelled or the repudiated. This is one of the terms written in the contract. So this is the conditions. And what are the warranties? So warranties means, let's say the buyers and the sellers are put into one contract, and it's been written that if the goods were not delivered till 20, for every day delay after 20, you will pay me rupees 5,000 or you will pay me the loss. So this is just covering the loss after the date of 20. It is not cancelling the contract. So this is called a warranty. This is the difference between the condition and warranty, which I think is important. Now, okay, that's it. With these two chapters, the next chapter is the Partnership Act. I will cover everything about the partnership in the next video. Till then, thank you. Have a nice day.